Welcome to Building Wealthy Habits podcast. Now, this features content and conversations with me, Randy Barkley, Jeremiah Lee, along with Laura Lee. On this podcast, we share financial advice from a team of certified financial planners, including a California licensed attorney, an MBA professional with collective experience of over 40 years.
All right, we're excited to host this week's episode. It's all about estate planning. We're going to break down what are some of the key essential elements of an estate plan. So Randy, Jeremiah, and myself talk on this week's episode about the top 3 key elements to an estate plan. This week's episode is honestly for anyone who is just starting into their independent adult life, so 18 to 20-year-olds. Oftentimes we don't think about them needing an estate plan, but in fact they could benefit from one. So anyone who has stepped into adult life and all the way up through the different phases of life. We also hear a lot of need to create an estate plan maybe shortly after someone who has experienced the loss of a parent or another family member. They all of a sudden realize that's maybe some of the motivation they need to come in and get all of their estate in order as well. So we hope you enjoy this week's episode of Building Wealthy Habits. Thanks for listening.
Some people are in the product business. They sell water bottles, things you get on Amazon. Some people are in the service business. They mow your grass. They fix something that breaks. There's other people who I think are in the trust business, meaning you have to trust them. And this came up this week. I've had a mechanic for years and years, and he retired. And then he kind of didn't retire. And then he did it again and went back and forth. But now he's finally and fully retired. So I had to get a new mechanic. And I think the mechanics are in the trust business. It's not just a, hey, do this thing for me, but really they're diagnosing. This gentleman we found, talked to a few people, found this guy. He's putting his hands on the engine. He's feeling, oh, it's this, and get into it. And I have to trust, that he's being honest. I have to trust that he knows what he's doing. I have to trust that he can do it timely. All those things, you have to trust this person. And when you do, man, that's a really easy, great relationship. If you don't trust that person and you're trying to check them and, let me see the belt, is it really that worn, and make your own opinions, man, it's so much harder. And I think it was a good relation like that. We are in the trust business. We do math, we do planning, we do investments, but really if someone can build a relationship of trust, man, it's so much easier as we move forward. And it just jumped out to me. I want to start with that. Yeah. Do you guys have people in your life that you say, hey, this is the trust business?
Well, again, I think your reference to the mechanic, I've always said finding a good mechanic is much like finding a good physician. It's so critically important that you have somebody that you can, so to speak, lay yourself out, and they're going not to take advantage of you, and they're going to say, this is what I think is wrong, and where they're certain, you have to agree with that, and where they're uncertain, they're going to do some more investigation and come back with your opinion. That's really critically important. It takes a long time to establish that, right?
Mm-hmm. Absolutely. I was going to say, even especially for the ladies out there, like the person who does my hair, like that takes time. You develop a relationship there. There is 100% a loyalty. Now, it's not a contract. It's like an unwritten rule, but you're expecting them not to overcharge you. You're expecting them to deliver a similar outcome every time. It's not like I show up to my hairstylist and think, oh, maybe my hair's going to be red today after I get it, So, and I just feel so much better about finding a trusted mechanic. It's not like you have multiple of those in your phone. You get one and you stick with that mechanic for as long as possible. So
That's right. Yeah. That's good. Well, that's a good segue is we do financial planning, we do wealth management, we do legal services, and those are all trusted advice ones. And today we're talking, I'm excited about it. It's in my wheelhouse here. We're talking about wills and trusts and those types of things. We have so many questions when people come in, and I'm always amazed with kind of the expectations that people have of what a trust is, what a will is. So we're just going to talk about some real basics to kind of arm the listeners of, hey, what's a will? What's a trust? What might you need? What might you not need? So to kick us off, question for you, married couple, they have 2 kids. One of them dies. It's really unfortunate, but they've done 0 estate planning. Who gets their stuff? What do you think?
Who gets the children's stuff or the kids' stuff?
The
I mean,
parent stuff.
the parent stuff. Okay.
Yeah.
Well, again, it's probably going to go to their nearest relative. It's going to go to each other. Then it would go to the nearest relative of the surviving spouse, I would think.
Does
Does
this
that make
couple
sense?
reside? Does this couple reside in California?
Yep, California couple. This is all California stuff. They, married couple. What do you think?
Okay, I love questions like this. Okay, so for the most part, because California is a community property state, it's all going to transfer to the surviving spouse. Now, if you told me that both parents had passed away, then, and there was no will, then it goes to court, or it starts the probate process, and they look at the titling of the various assets. So things that have a designated beneficiary. So let's assume there was some sort of retirement account where you have to denote a beneficiary. Those are things that automatically transfer outside of the probate process. Any sort of bank accounts that have a TOD or transfer on death, that's kind of similar to that beneficiary status. But if something isn't titled appropriately, or there's not a will or a trust set up, then it essentially goes to court, and the court has to appoint a person, there's a name for it, that would oversee the
That would be
distribution of
executor
assets.
or executrix, right? What's the difference?
Just male and female.
I think
that's
you
an easy
just
one.
talked Harry Potter talk on this
That's
podcast.
right. No, that's right.
That's exactly what they do. They just wave their wand, and then everything is
It's-
transferred
so-
to the next.
Way to go for both of you. Laura, you jumped right into the weeds of what it is, but here's just they call it intestate, meaning you died with no estate planning. You just passed away. So it means intestate, and California has some default rules. This is what happens. So here's the kicker. Most people think if I die, my spouse gets everything.
Yes.
And for the community property, hey, that works out. But for separate property, so say, the one who passed away had an inheritance, had some assets before they got married, the spouse is only going to get a third of that. And the kids, even though they're minors or if they're adults, they're going to get 2/3 of that separate property. And for most people, they say, wait, that's not what I want. My wife is still, or my spouse is still living. And so when estate planning comes in, wills and trusts and all that, is to say whatever the California default rules are, if they're not going to line up with your life, which there's very few people I've had that look at those and say, yeah, that's exactly what I want. Who's going to get your stuff is different. And the process of probate is the way the court supervises kind of divvying out and dividing up someone's estate. And so you can put in a will or a trust to basically get away from those default rules and build out how you want your estate to be administered. And like I said, in California, the default rules don't line up with most people expect. There's some situations with you, but usually don't. So we can jump in. I just want to start with the intestate.
Let's just say again, probate is not a place you want to be.
Well, again,
yeah, go ahead.
Probate has a purpose, right? It
Absolutely.
is. So you have, if you have differences between different beneficiaries, or in some cases, you're trying to protect the people that have the least amount of ability to protect themselves. Probate is a way in which that can be dealt with in a very judicious way. I mean, there's a purpose for it, right, Jeremiah?
Absolutely. There's a great purpose, and there's a lot of people who practice in this. Probate judges and probate attorneys, probate advisors. To get people through this. But for most people who can, before they get to that point, plan their estate, they have a massive benefit of cost and time of just avoiding probate. And I often in client meetings will compare it to the DMV. I apologize to any DMV workers out there, but that if you like the DMV, you're going to love probate. There's lines, it's public, there's a lot of forms, there's a lot of red tape. It serves a very important purpose, just like you said, Randy. But for a lot of people, they would like to avoid probate, the cost and the time delay, and use a will or a trust or things like that. Now,
right.
Something I just said.
I just want to put a pin too in what you said about it being public. And I think for many of us, it's not like we're some famous person. We're not too concerned about somebody looking into all of our details after we die. But there might be some sensitive issues among family members or others. And if you're forced to go through the probate process, that's all public proceedings. So all of that information is kind of laid out there for.
Yeah,
right.
There's some famous wills that you can Google them. I think there's Kennedy's will, Nancy Kennedy, I believe, that's public. And there's people who, when it became public, because it gets filed with the court, they went through and saw all these gifts that were made in there. And, there's the intrigue. Well, why did they give this to this person? If you were to do that in a will, or not in a will, sorry, if you do it in a will, it's public. If you were to do that in a trust, it's all private. And so
Right.
you can move that public sphere into a private sphere of who you're giving to, why you're giving to them. All that can be in a trust. So
Yep.
let's
Great
move.
question. Good test. I love
Yeah,
questions.
it's a good time. You got all the answers in the weeds. So let's I kind of want to take a little bit of an overview of, when I think of estate planning, I think of all the pieces put together that is going to make it easy for the people that you love if you were to pass away. We just talked about intestate, and that's that fancy word that means if you died with no planning, you didn't do anything, you just lived a normal life and passed away. The first one that comes in that people think of is a will, and a will, which many listeners know and you guys know, it really all a will does is says at the time of my death, it kind of points where you want your assets to end up. It doesn't avoid probate. You're still going to have a judge oversee that process. It doesn't change the timing, meaning, hey, if my kids are in their 20s and they probably shouldn't receive all the money yet, let's spread it out until they're 25 or 30. The will doesn't do any of that. It just says at the time of my death, here's where I want my stuff to go.
Right.
California is a really unique state. I mean, some others have this too, but a unique state in that they accept what's called a holographic will. Any ideas on what that is? Is that like a hologram?
Well, I think a holographic, what I refer to is if somebody sat down and just wrote out, he says, I want my stuff to go to so-and-so and signs it, right?
Right, it's
Perfect.
a handwritten will. Now,
Handwritten
what's
will.
the oral will, where it's like on their deathbed they could declare?
Yeah, good luck. As I've not had to litigate those. My understanding is that California, an oral will is not a real thing, right? It's just kind of saying what it is. But if that's the situation, and get a real attorney to look into that for you and determine that. But I had a client not too long ago that brand new to me, is a friend of an existing client, and said, "Hey, I'm having some major surgery tomorrow, and I haven't done any estate planning, and here's what my life is structured." And we said, "Oh, your assets, if something were to happen, they're probably going to go here." And he said, "Yep, I don't want that at all." So he needed to get a will together. And timing wise, and developing that relationship, understanding his life, there was no way for me to interact with him that quickly to get a will drafted and signed. And so what we talked about, and the legal advice that was useful in that moment, was a holographic will, to say he can use his own hand and write everything has to be in his own handwriting, write it all out, sign it, and it's a valid binding will.
Do they have to be witnessed?
They don't have to be witnessed, don't have to be notarized.
Huh.
And
How do they prove that the deceased person was the one who actually authored it?
Yeah, handwriting. It's handwriting analysis. And that's why they require it.
Huh.
If you type it all up yourself and
Yeah.
then sign it, it won't work. Like that's not what a holographic
It
will
has
is.
to be handwritten.
Handwritten. Has this, and there's a few key things you have to hit to say, I understand what I'm doing. I understand my property. I want this to be a final and setting out my last desires, where my things might go. And anyway, some other bells and whistles. But
I think other things to point out too about a will, and for those of us parents and those who are listening who are parents, a will can also appoint guardianship, right?
Yep.
So for your children, who then would take care of your children upon the death of both
That's right.
spouses?
That's right. It's a great comment, and it's not in the trust. And so that's a common, when someone will come and meet with me, we'll start putting together their trust. They'll say, "Oh, I probably don't need a will. I have a trust." We say, "Well, the trust is the main document, of course. However, the will is on the sidelines, and it has some purposes. And one of the purpose is to appoint guardians. If they have minor children, that sometimes you can use a separate document, but most people will do that as part of their will, that it goes before the court if something were to happen to both of them, and they're able to designate who they want to take care of their kids."
And the other person, to Dad's point earlier, is your will can state your preferred executor, right?
Yep.
So the person that you choose to oversee the distribution of your assets or the administration of your estate versus the court, like in the intestate. Wow, this is there's lots of terminology on this one.
Yeah.
Situation where the court is going to appoint the executor.
Yeah, and what we have found out working with families and helping them establish their estate plan, and what we found is that they have a tendency to name birth order. So the oldest child, so to speak, is now the number one executor, and then they name the second one in birth order. And oftentimes that may not necessarily be the right fit, right?
Right. I feel like actually more often than not with our clients who have a will, it's not necessarily in that order. But typically, both spouses, from what I've seen, agree. It's like they both automatically know, yep, Tom's the best one to oversee our will. It doesn't seem like I'm sure in some cases there's a lot of negotiation and conversation around that. But in my experience, it's been that both parents kind of can identify who's going to be the responsible one
Pretty obvious. That's right. That's good. So before we jump into that's a will. We kind of talked about that. We'll talk about a trust in a little bit, but before we get there, there's some real important pieces that I think when people think of a will or a trust or estate plan, they think of death. But there's a few items that are really important that are pre-death that are
Right.
part of an estate plan, and those are called powers of attorney. And so there's two main forms that we use. One is for financial items. So if you're in a car accident and you're in a hospital and someone needs to get into your bank account to pay your mortgage, someone needs to go and talk with your cell phone carrier to get you a new cell phone because the other one was destroyed in the car accident. They need to do something financial for you. Generally, they can't. I mean, I don't have the right to get into anybody else's bank account. However, if you have this power of attorney, you've pre-named somebody that they, in a situation where needed, they can go and get into your bank account. They can deal with any sort of different organizations on your behalf. So that's a key one. Is that someone can deal with your finances if you can't. And the second is the power of attorney for healthcare. Often it's called an advanced healthcare directive. And this is if you can't make a medical choice for yourself, you can name who you'd like. And these, sometimes people just say, well, it's my spouse or it's my kids. But it's really, really, I'd say valuable to a family to have someone designated. So it doesn't turn into a doctor just looking to the group or the group trying to, by consensus, talk through this. Often families, they'll have, a daughter who's a nurse or someone who else is in the medical field that it's an obvious choice. They say, oh, well, I would want this person. They know what I care about. They would make the same choices I would make. They'll understand what the doctor's saying. So even though, of course, they would get family input and, there'd be a moment where the family hopefully can come together, but empowering someone that you trust to make a good choice for you is so important. So those are both two key things that are in your life.
And let's talk about, we had a very real life personal example of this recently. Yeah. We share a family member who had some ongoing health issues, but they got very serious very quickly. And even though actually the POA documents had been drafted, this family member had not yet signed them. And actually went into a situation, was hospitalized, was unconscious, unable to make decisions for herself for a matter of weeks, at least 3 to 4. So at that point, you're thinking about there's bills that need to be paid, whether it's a mortgage or your housing payment or your phone payment or et cetera, and there was no POA in place. So both the financial and the medical POA were absent, and that was an extremely stressful situation. Now, as she regained consciousness, she was able to sign those documents, and they're still helpful because even as she's healing, this is turning into kind of a long-term care situation. In the meantime, other family members took over paying her bills, and there was fraud, come to find out, on one of her savings accounts. And the entire account was completely depleted. And so if there wasn't that POA in place, she's not able to go to her credit union or her bank to just identify the fraud and resolve the issue. So anyways, that was our personal example recently about how effective and how meaningful, and you can't expect the timing of when you're going to need it.
So the question I have, Jeremiah, is that somebody has a durable power of attorney for financial affairs, and the institution, let's say the bank, says no, and this is after the person has become ill, and the institution says, we're not going to honor that one. We want our form signed, and then it's too late. The person is already declined in health and not able to sign. What's the remedy there?
Yeah, that's a good question. So sometimes it turns into a fight. A lot of banks like to have their own forms. A lot of institutions like to have their own things done. So if you knew this was coming, you could connect with Wells Fargo, Bank of America, Chase, whoever it may be, and make sure you have those set up on their forms. A personal story, I have a good friend that her father had dementia and had signed a power of attorney years prior, powering the mom to do all sorts of things with their real estate and different accounts. Well, at one point, there was a lender who would not honor the power of attorney and said, no, we're not going to let you, do this transaction and move forward with this loan because he has to sign and we won't acknowledge the power of attorney. Well, it ended up being my friend who's also an attorney and myself and another attorney on a phone, basically bringing up the prospects of litigation and how this is going to be a huge fight. And we ended up finding a good solution and we were able to move forward. But it comes to those moments sometimes where if a bank is not willing to honor it, that it would need to be a fight to say if it's legally and effectively done, the bank, in my perspective as an attorney, would need to honor that. But of course, each situation's different, but right. To connect with an attorney to say if this is important to kind of push that through could be
Because in
needed.
that case scenario, the POA was actually protecting that individual's interests. And by not honoring the POA, you're essentially limiting their authority and
Yep.
their own right. So, I mean, talk
Yeah,
about
that's
a
great.
battle to fight. I think that's a worthwhile battle.
It was a good one.
Dad, you brought up a really good term. So I get to ask Jeremiah the question now. Tell us, and for our listeners, what's the difference between durable power of attorney and non-durable power of attorney?
Oh, that's great. This is like a law school 101 question of whenever you empower someone to do something on your behalf, they only have the power that you have to do. And so in a normal instance, if I empowered Laura to go and do a real estate transaction for me, her power is only as far as I can have that power. Well, in a durable power of attorney, you're stepping out of that normal framework and saying, even if I was unconscious, even if I didn't have the power in that moment by myself, I still want her to have the power to do this thing. So a durable power of attorney doesn't extend beyond death, but it does extend beyond conscious ability to handle something. So in mental incapacity is the major one, or just physical incapacity. But a durable will remain beyond that, even though the person who signed it is not capable at the moment. So the durable power of attorney is a key term of what you'd want to set up.
So again, a power of attorney, my understanding, and correct me if I'm wrong, Jeremiah, but a power of attorney is only effective while the person is still alive. Is that correct?
That's right. Yeah, it will cease at their death because they're no longer able to empower agents because they're not alive. And often, when you think of this estate planning packet, the power of attorney, the healthcare directive, those are useful up until the moment of death. The moment of death, it then clicks over into the will and or the trust are the main things that usually take over at that point. That's why it's important to have a whole estate planning package. And one other piece I'll just throw out for our listeners, this is, I think, a key value here, is if you have kids and your kids turn 18, as a parent, you no longer have medical authority in their life. You no longer have financial authority in their life. And there's a number of folks that, their kids are going off to college, they're excited, hooray. But it's fairly important in that moment to get a medical power of attorney for your kid. Because really as they go off to college, they turn 18, something happens, they're in a hospital, it's really appropriate in most families, is exactly what they want, is that they call the parents and they'll look to the parents to make a medical choice if the child isn't able to, even as an adult. And that's what I think that is entirely overlooked by most people. They don't even have that in their mindset. But to think about that, as children become adults, is there any sort of care that you need to set? Because often they're not married. Often they're single. Often they're in essence, a vulnerable place without having some of these. So that's I'm going to say a freebie, but that's I think a good nugget of when your kids are going to college, think about setting up some advanced healthcare directives or powers of attorney in the case you need it.
That is really helpful. So let me just real quick, just give an example of when you would use a non-durable power of attorney, which my understanding is it's a very limited authority. So just give us an example of when you would use a non-durable.
Yeah, you'll sign those at times. Say in your closing a real estate deal, often there's a power of attorney that you sign that allows the escrow company to record the deed on your behalf. You're not empowering them to get into your bank account. You're not empowering them to make medical choices for you. You're just saying, in the midst of this transaction, you're able to file this on my behalf, and things of that nature. They're very usually short in time and specific in what they're doing. Is a normal power of attorney, but a durable power of attorney, that's when you're usually empowering someone to make all sorts of choices for you in the event it's needed. And it's usually a very trusted person you would be giving that to.
Right. Well, we have truly taken a deep dive, so we just have a couple more minutes, but I think the last most essential piece of an estate plan that we want to talk about is that big word that we started with, a trust.
A trust, yeah.
Do you want to just give kind of a brief? There are many different kinds of trust. They can be all utilized in strategic ways. Do you want to just give us an overview of some typical trusts that you find in an estate plan?
Yeah, that's great. Great question and good lead in. I would say, when I think of a trust, I think of like a treasure box. You think of, some pirate treasure. You open this box, whatever you put in that box is controlled by the box. And if something were to happen to you, you just pass along the keys to the next generation or to whoever that's going to be. And so part of it is setting up this box, this treasure box, to say, I don't want these assets to go through probate. I don't want them to be up in the air. I want it to be very certain of put them in this trust, and then this trust controls them. And then there's some marching orders that say, if something happens to me, these go to this person. So that's the normal trust. There's a whole bunch of, they call them irrevocable trusts. And we do that for large estates. We do that for a number of reasons. But the majority of people out there that are thinking about their estate planning, they're thinking about a revocable trust or a living trust. It's something that you would set up. It's just like a treasure box, but you can put things in, you could take it out. It's really a probate avoidance and future planning tool.
But you're
And-
able to make choices. Irrevocable means you are not able to revoke that trust. However, it does remove whatever asset is placed in that irrevocable trust, life insurance being one, etc. It removes it from your estate for the purposes of estate tax.
So there are some assets typically that you would put into a trust titling, but there's some assets that you wouldn't, right?
Yeah. And the key ones, and there's actually a bunch that you wouldn't. And we always have that conversation with clients as we get a trust in place. We then go through basically their whole life of kind of combing through. And that's the benefit of us being, legal side as well as wealth management side, that we can look through their whole life and say, hey, here are the ones that need to go in the trust. Here's the ones that don't. But to your comment, Randy, the ones that really jump to mind is real estate. Anything that's real estate in California, you very likely want to get that in a trust. The other one is large taxable investment accounts or large taxable savings accounts. And when I say large, over $150,000, all of those, you want to get that stuff in a trust. It's pretty vital that you do.
Yep. Well, that about wraps up our time. There is a plethora of information around estate tax, estate planning, etc. So if you have more questions for our team or specifically for Jeremiah, please contact us. We'd be happy to help you. Thanks so much for listening today, folks.
Until next week, folks, may you grow in wisdom and knowledge. Thank you for listening.
We have a few more things to let you know about before we go. Podcast reviews really help us to serve more people and get this information into the hands of the people who need it. Please leave us a review. Even if it's not 5 stars, we welcome the feedback.
And we invite you to let us know what topics you would like to hear more about or what would benefit the people in your life who you're closest to. We have more resources online. Those resources are designed to help you share this great information easily with people in your life. To access those resources, please visit trichordadvisors.com.
Often we hear from clients that they wish they had talked to us sooner. If that's you, we'd be thrilled to see how financial planning can benefit your life. Email us at contact@trichordadvisors.com or simply click on the link in the show notes.
This show was produced by Graham Gardner at Model FA. Find out more about how to create a podcast for your financial planning business by visiting modelfa.com. We love creating content that's useful, resourceful, and maybe even a little entertaining. We want to make this mega universe of financial topics and advice applicable and helpful to your life.
Remember, at Trichord Advisors, we are your future's best ally.